The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, I'm Kevin O'Flaherty. I hope you enjoyed this Learn About Law video and podcast presented by O'Flaherty Law. If you need some help, please feel free to give us a call at 563-503-6910. That's 563-503-6910. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. Thanks again for watching and listening.
Hi, this is Andrew with Learn About Law, and in today's video we'll be discussing the written discovery phase of civil litigation in regard to Iowa. So we'll answer questions such as how does written discovery fit into the overall civil lawsuit process, what does written discovery entail, and how long does written discovery take. So civil cases normally fall into one of three categories. Contract law, so contracts and agreements between persons or businesses, family law, so divorce, child custody, alimony, etc., and tort law, property damage claims, personal injury, liability, stuff like that. So generally the process of civil litigation is the same for each category, with some slight differences for family and small claims. Also in 2015, Iowa made some dramatic changes to portions of its civil litigation process, one being its fast-track litigation process and other being changes in the general discovery rules for civil cases. So it can be kind of easy to be confused by the entire process of civil litigation. Without some prior experience or general knowledge, it may seem like a lawsuit is filed and you quickly end up in court battling it out with the other party. But in reality, only around 0.6% of civil litigation cases actually make it to the trial phase. Not necessarily because there's no case to be had, although that is one reason, but rather the case is resolved without the need for a trial. How does that work, you might ask? Well, if it's the case, then what is my attorney doing, right? So, a significant portion of pretrial work is the discovery process. If you've watched even a handful of movies, like surrounding a court case, legal proceedings, or about law in general, you probably remember scenes of stressed out men and women in suits poring over stacks of paper in the early morning hours. It almost seems like they're doing the work of like a detective, right, or a private eye or something like that. Well, actually, to some degree, they are. So it is your attorney's job to research the facts surrounding your case. The bulk of the discovery process is to figure out what happened, what led to the lawsuit being filed, information about the opposing party, and all the other pertinent facts surrounding the case so that later a convincing narrative that supports your side can be constructed. Often, the case will settle during this phase because one side or the other comes across facts that signal to the attorney that the case will likely lose at trial. So a civil action is initiated when the filing party files his or her complaint in the appropriate court. In most situations, the filing party is referred to as the plaintiff and the opposing party the defendant. The claim, often called the petition, explains who is involved in the suit, the legal claims, and any remedies sought by the plaintiff. The petition asks to be served to the opposing party, hence the "you've been served" line that shows up in TV and movies. After this, the opposing party can file his or her answer, admitting or denying liability, barring any pretrial motions such as motion to dismiss. Following the initiation of the lawsuit, the discovery process then begins. Note, a motion to dismiss can still be put forth during the discovery process after it starts. Next, let's talk about what is a discovery process, or the discovery process in general. So in Iowa, the discovery phase can't commence until both parties meet for a discovery planning meeting. The law requires that certain information under the initial disclosure be collected for the case immediately after the discovery conference prior to the beginning of the discovery process. The information under the initial disclosure includes, but is not limited to, things like names, addresses, telephone numbers, emails, people who are going to be pulled into the discovery process, all documents, stored information, and other tangible information the disclosing party has in its possessions that they feel would be beneficial to the case. In a personal or emotional injury cases, certain insurance and medical information and things like signed waivers allowing access to that information. And then in claims involving lost time or earning capacity, you've got things like employer and work-related information. And then in claims involving domestic relations, things like pay stubs, federal and tax state reports, account information, and if children are involved, usually some computation of child care needs. So the discovery planning conference must take place no more than 21 days after the serving of the lawsuit, and the discovery planning meeting, both parties and their attorneys must discuss the nature and basis for their complaints and any possibility of quickly resolving the case, make or arrange for disclosures, and cover any potential problems when preserving discoverable information, and make a plan for the preceding discovery process. So the point of this meeting is to, 1, see if the case can be resolved immediately, and 2, be on the same page as far as what will be asked for, and then 3, develop a plan so that everyone understands what will transpire during the discovery process, and hopefully get it done as quickly as possible. So finally, we get to the written discovery portion itself. So written discovery, as the name implies, deals with the document portion of the discovery process. It can be broken down into four categories of documents. So you've got written interrogatories. These are written requests to the opposing party which must be answered in writing. Any request for production of these documents, these are like requests asking the opposing party to make available certain documents in its possession for the requester. Then there's third-party subpoenas. These are written interrogatories and requests for production of documents made to individuals and organizations not a party to the lawsuit. And then you've got requests for admissions of facts. These are documents associated with the opposing party requesting for the validity of certain documents and to admit or deny certain facts. So it's normal for either side to issue objections against any number of initial requests for interrogatories or production of documents. The opposing party attempts to support these objections under one of the following bases. So the discovery request seeks documents or interrogatories not relevant to the case. The request is too broad and not tailored to discovering only relevant information. The discovery request would require a disproportionate amount of time or manpower versus its relevance to the case, and it violates attorney-client privilege. So if the objecting party withholds the information that it believes is not discoverable or does not respond within a timely manner, the requesting party can write a letter to the objecting party detailing why it believes the objecting party is unlawfully withholding information. This letter details the withholding party's responses, argues why the withholding party's responses are deficient, and asks that the withholding party fulfill the discovery request within a specific period of time. With the introduction of changes to civil litigation process in Iowa and its focus on fast-track litigation, the law is even more focused on the two parties working out their discovery objections outside of court and in a timely manner. If the two parties are unable to come to an agreement on certain objections, then a motion to compel can be put forth. So basically, a motion to compel asks the judge to order the opposing party to answer the discovery inquiry more fully or appropriately. If the judge grants the motion, the opposing party may be required to pay the attorney fees associated with the delay due to the objections. If the opposing party continues to refuse an appropriate answer, then they will be held in contempt. So how long does this whole written discovery process take? Well, depending on the case, written discovery can be definitely a timely process, lasting anywhere from a couple months to over a year. As more and more information comes to light during the discovery process, it is not uncommon for either party to issue a second or third set of interrogatories and requests. In the Iowa, plaintiffs have the option to choose an expended civil action lawsuit. This process requires the case to be tried in 1 year or less, meaning the discovery process must move at a quicker pace, and the award is limited to $75,000. This process also limits some portions of the written discovery and pretrial procedures and allows a trial to move forward with a jury of 6 persons and limits an attorney's time to 6 hours for certain portions of the trial, including things like openings, direct and cross-examination, and closings. Other new rules also obtain to the fast-track litigation process in Iowa. So ideally, both sides get as much complete and satisfactory information from the opposing party before scheduling depositions. The purpose of all this information in the discovery process is twofold. So first, depositions are costly. The discovery process allows your attorney to narrow his or her focus in order to lessen your overall cost and create a more consistent, coherent argument. Second, competent written discovery prevents deponents from giving incomplete or non-essential answers during the deposition. The discovery phase can feel long and frustrating, right? So to the plaintiff and/or defendant, but a thorough discovery is what wins cases, whether they go to trial, settle pretrial, or are resolved under some motion prior to trial. And always, if you have any questions about civil litigation or anything else, don't hesitate to reach out to our legal professionals at O'Flaherty Law. Thanks for tuning in.
Hi, Kevin O'Flaherty again. Hope you enjoyed that presentation of Learn About Law presented by O'Flaherty Law. If you need some help, please give us a call, 563-503-6910, 563-503-6910. Again, we offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.